Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? I'm still a law student and this happened during my first internship at a court. A girl among other people was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, it could have been one of the other people as well who still had drugs on them. The judge ruled in dubio pro reo, equals reasonable doubt I think. He then asked if she wants to say/add something and this girl asked if she can get her drugs back. The defense attorney looked like he was about to get a heart attack. This is by far the stupidest one on here, I think. She did something wrong, got away with it, and then you edit up. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head, thus it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B, and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along, "Thrown, eh?" And the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason, he organized via Craigslist to have someone collect a box of his cum from a children's playground. There were explicit messages from him asking what they did with it, and whether they rubbed it all over themselves. The employer provided us the messages. Edit, he was doing this on company time. Jesus. If you're going to be a creep, don't do it on company time. Equipment. WTF is wrong with people? FDA dismissed a guy for insider trading. He would access a database of drugs about to be approved, which nearly always caused stock to go up. He'd made millions buying stock in his family's name to cover his tracks. But he made a fatal mistake. He looked at the database and then bought stock with his work computer, which FDA owned and could search without consent. You click a statement to that effect each time you sign on. If he'd waited and done it on his own computer, they'd have had to get a search warrant, a much tougher proposition. UK, not a lawyer as such, but a planning consultant. Client signed sworn affidavit stating he'd been running a truck park business for over 10 years on a piece of land. After 10 years the use becomes immune from legal action. The counsel checked Google Maps and saw immediately he lied, had only ran the business for 7 years. He had committed a criminal offense by submitting a false sworn affidavit. Longer. Sounds like something typical of owners of truck parks etc. My dad was for many years involved in ensuring these kind of people, waste disposal firms etc. operate in compliance with environmental law. He had no end of tales about how impossible they were to work with, even when they weren't in the wrong. It's a shady field of business, had something similar. A couple of gypsies had been using this commercial yard with a barn on it as a base for their carpentry business. Multiple deliveries for timber a week. They submitted planning for a barn conversion for a house, stating that no commercial operations had been carried out for the last 10 years and so it was viable for permitted development. The planning officer walked up the lane on his inspection as they were unloading a bunch of timber, lots of commercial vehicles about. His planning report, which is usually several pages long, simply stated, "Commercial premises still in use," contrary to submitted statement from the applicant. I was actually on a jury. Guy was suing a business, said he got injured, couldn't work for 3 years. Defense counsel: Sir, isn't it true that you spent 18 of those months in prison for armed robbery? Edit. For more info, Guy was saying he was shopping at a major grocery store chain and slipped in some water on the ground in front of a freezer. Guy has cell phone video his wife made of him in the water, and we could hear her saying that the water wasn't showing up on video and to splash it with his hands so it would look better in the video. It also came out that he'd had 3 prior convictions for crimes of dishonesty, that may not be the exact term, but something similar, for things like shoplifting and other petty crimes. Theoretically, does it change anything? Sure, the robber is likely a scumbag, and everyone in the courtroom is now less likely to trust him. But if there is medical evidence proving that he was unable to work for 3 years, and other evidence proving that it was the business's fault, what difference does it make that he spent half of that time locked up? You can work and earn money in some prisons, too. Past crimes of a dishonest nature are usually submitted as character evidence. It may be used to show that giving false testimony isn't exactly a stretch for that person. There are specific rules that need to be followed for that submitting that type of evidence though. People think they can sue the store for enormous amounts of money. They usually can't. You have to prove the store was negligent. This could be they knew about it, weren't doing floor sweeps, knew about the wet spot, etc. In most cases they don't. Often another customer causes the spill. Besides, if there's no real injuries or something simple like a sprain, you're not even going to sniff $1,000. Client and family law matter lied to me about using meth. Then used meth with the child in the room, and the ex got footage of it on the nanny cam and then made excuses about why they couldn't do a drug test, then blamed me when they lost custody. Despite the fact that they didn't show up to appointments or return my calls, so I couldn't prepare any court material. I dumped the client after that and left family law. I had a client who had practiced family law for over 20 years. Her last straw was an emancipation case for a 16-year-old girl, I think. She read the case file, threw up, and decided that was it. Finished the case and never worked family law again. I'm a gal. I called and texted the father on one of my cases around 10 times in the weeks before the hearing. He wouldn't call back. If he answered, he would say he was too busy to talk to me. A couple hours before the hearing, I was volunteering at my son's school for an event and he texted me saying he was ready to talk. I let him know that I couldn't call. When I got to court, I found him and introduced myself. I told him I would like to talk to him after the hearing. He said, "Oh, you got time for me now?" The judge awarded temporary custody to the child's grandmother. When we left the courtroom, he starts going off about how we are all unfair against fathers. Not only did the judge award custody to the grandmother rather than the mother, but he didn't really want to discuss his prior or current charges, including DV, drug and gun charges that occurred in the presence of the children, lack of driver's license due to DUI, or refusal to submit to the court-ordered drug test. His lack of custody was due to my bias against dads. It was a typical appointment, interview with the immigration committee in order to grant my client a residence permit. He was marrying a woman in my country with my country's nationality, and this is a legitimate reason to be granted a residence permit. So it was a typical procedure. At least that's what I thought. The committee is bored to death and we all want to be over with it, so they ask him all typical and boring questions, like how did they meet, where they live, etc. They ask these things to identify white, false marriages. At some point they ask him if he was married before and he says yes, back in my home country, and I am still married actually, never got a divorce. WTF, I was stunned. Double marriage is forbidden in my country. And he never bothered to mention this detail to me, neither to the other lawyer when we asked him. He later told me he said the truth because he was afraid to lie in front of a committee. An honest and stupid man. I got all my money though, yet we had to find another way to gain a residence permit. I felt a too real shudder of recognition reading your story. So many times I've asked a client the exact same question like 5 different ways just to make sure their answer remains consistent. Just to have them answer in the exact opposite way before the judge or decision maker during the hearing. Like, "Phoo, why even retain me if you're not even going to stick to the plan you're paying me money for?" one of the unsolved mysteries of life, eternally. I'm an immigration paralegal and this kind of thing happens all the time. I always ask if they are married, and they say no. Later on it comes out that they are married, but it's in another country so it doesn't count. Nope. It still counts. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, at any point in the marriage, did you lay your hands on your wife? One time we were having an argument and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all the alarm bells were going off in her head because he had never mentioned this and, apparently, to him, this was not abuse. The judge gave wife a lot more money as a result and husband was baffled. My mentor was fuming. EDA, husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community. Hence why she was so damn shocked at his answer. A defendant was written a cell phone ticket while driving and defended himself. Your Honor, I was not using a smartphone while driving. I was actually using a flip phone. Guilty. The lawyer was an idiot for not instructing him correctly. Most states allow using Google Maps as a defense. So as a technicality, if it stated on the ticket that he was using a smartphone and he was able to prove he didn't own a smartphone, without saying he was using one at the time, would that get him off? Edit. My intention with this would be hoping the defendant wouldn't be dumb enough to then say it is this instead but rather just say no, I do not own a smartphone so I could not have been operating one while driving, a truthful and whole statement under oath. I'd assume any good lawyer would then press for further details and have it collapse, but I'm also spending my evening on Reddit so what do I know? Apparently my cousin-in-law got out of a ticket in a similar way. She didn't accept it, went to court, and the judge said "M's crazy, you want me to believe you were just driving with the cell phone in your hand and you weren't using it?" And supposedly, she responded with "Your Honor, you're holding your pen right now and not using it?" We were told he dismissed the ticket based on that response. I never bought it. The next logical step for me would be I'm about to use my pen. Intent to use a cell phone while driving isn't a crime I guess, but it shows to me it's not enough to dismiss the charge. Alas, I'm only the legend keeper of my family, and forbidden by the laws of my ancestors to stir up shit by asking questions. I did some personal injury stuff before I went into teaching. This wasn't my client, but rather the person trying to sue them for 7 figures. I imagine his lawyers wouldn't have been too pleased with the fact he failed to mention the 2 reality TV shows he'd been on since the accident. He was trying to claim 7 figures for a brain injury that supposedly ruined his life, yet half the country had watched him be perfectly fine on TV, and a quick Google brought all of it up to us. Trial was supposed to last 3 days, we were done by that afternoon. I work for an insurance company. A guy sued one of our insureds for, among other things, loss of consortium, which can encompass many things but namely the ability to have say with your spouse. We had gotten surveillance on the guy and had video of him having say in a car with a woman other than his wife. For whatever reason his attorney took it to trial anyway. He continued to deny the ability to have say. The video was played for the jury and the guy's wife who was at the trial. He lost the trial and his wife. Doesn't always work that way. In Boston, a 40-year-old firefighter claimed a debilitating back injury from moving a file cabinet and got a full disability pension plus. Several years later, Video emerged of him competing in bodybuilding competitions all over the country. Big brouhaha in the press and his pension benefits were taken away. He then took it to arbitration and won all benefits back plus back pay. Seems competing in bodybuilding contests is not proof that debilitating pain is still not present. Shouldn't this have been something the defense team easily discovered while building their case? I guess I don't know what sort of investigation of their own client an attorney goes through, but it seems like they should have been aware of something so publicly available. Unfair dismissal case. The client claimed to have been dismissed without reason or following procedure. After we had started the case, it comes out that not only was he given 3 written warnings but he was also called in for a disciplinary hearing before his dismissal. Don't lie to your lawyer. Had a similar case in regards to tenant law and an eviction order. Dude claimed he never got the written warnings of his landlord. 10 minutes into the case he admits not having checked his letterbox for months due to being over at his GF's place most of the time and was afraid to find letters of his landlord due to missing rent. Still got him a deferral to pay the missing rent in full within 30 days to avoid the eviction. Of course he did not. Sigh. Not a lawyer, but going to law school. I worked for a defense attorney who did a lot of federal work. One of our cases was with this guy charged with say trafficking of minors. We met him at the prison to interview him and he swore up and down he had nothing to do with this and that he didn't even know the girls. A month or so later, heaps of evidence from the U.S. Attorney's Office comes in and it's pages of Snapchat messages and texts between him and these girls, video confessions from every co-defendant and victim saying our guy was the ringleader, proof of him checking in, out of different motel rooms, etc. We showed him the evidence and he claimed his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial but we repeatedly told him that would not be wise because of all the evidence against him. He ended up requesting a new attorney to be appointed claiming that we were ineffective. To this day my old boss and I reminisce about how difficult this client was when we catch up on the phone. Not a lawyer but a woman I know received several hefty speeding fines. In my country you can go see a magistrate to have the fines reduced if you plead poverty. She heard about this and decided to give it a shot, so she went to court and told the magistrate a sob story about not having enough money. The magistrate heard her out. Then he asked her, "Madam, what type of car do you drive?" She replied in a tiny voice, "A Porsche." Reminds me of an article I read a few years back about a family who was fairly well off. Then the recession hit and they lost their jobs, their house, and sold most of their material goods. One of the things they kept was their paid-off luxury car because it made more sense to keep it as a reliable vehicle compared to whatever they could do with the money selling it would have netted, since even luxury cars depreciate fast and hard compared to other assets. Probably not the case here, but it did give me something to think about. Check out our other videos and subscribe and leave your suggestions and experiences in the comments below. Have a great day.